The subpoena arrived on a Thursday afternoon, delivered by a process server who wouldn't quite meet my eyes when he handed it to me. I remember standing in my driveway reading the caption at the top of the page: Fairview Meadows Homeowners Association versus Daniel Cross. Below that, in smaller print, a request for injunctive relief regarding unauthorized water extraction and a demand for $240,000 in damages. I read it twice before I started laughing, not because it was funny, but because I genuinely couldn't believe the audacity of it. My family had been pulling water out of that well since before Fairview Meadows was anything more than scrub brush and jackrabbits. And now a homeowners association built on land my grandfather used to run sheep on wanted to sue me for using my own water. My name is Daniel Cross. I'm 47 years old, and I run about 300 acres of irrigated alfalfa and a small herd of cattle out here in the high desert. Land that's been in my family since 1958, when my grandfather bought it for almost nothing because everyone else thought it was too dry to be worth farming. He proved them wrong the same way most stubborn men prove people wrong out here, by drilling deep enough to find water nobody else believed was there. That well has run every single day since 1961. It waters my alfalfa, it fills my stock tanks, and until about 6 years ago, nobody outside my own family had ever given it a second thought. Then Fairview Meadows estates went up on the ridge above my north pasture, 400 and some homes packed in tight where there used to be open range, and everything changed. I want to back up about 8 months before that subpoena showed up, because that's really where this whole mess started, with a woman named Priscilla Vance standing at my front gate holding a bottle of sparkling water like it was some kind of peace offering. Priscilla was the president of the Fairview Meadows Homeowners Association, and I want to be fair to her, because in the beginning she was polite enough. She introduced herself, told me she appreciated how well I kept my fences, made some small talk about the weather. Then she got to the reason she'd actually driven down my long gravel driveway. We've had some concerns raised at recent board meetings, she said, about groundwater levels in the area. Several residents have noticed their sprinkler systems running a little weaker than they used to. I told her that sounded like a plumbing problem, not a groundwater problem, and she gave me a tight little smile, the kind people give you right before they say something they've clearly rehearsed. Our engineering consultant believes the shared aquifer beneath this basin may be under stress from unregulated agricultural extraction, she said. We'd like to discuss options for limiting non-essential water usage in the area. Non-essential. That word sat wrong with me from the very first time I heard it, because my alfalfa wasn't non-essential to me. It was my living. But I kept my voice level, because I've learned over the years that getting loud with people like Priscilla just gives them something to write down in a complaint file later. My well's been running since before your subdivision existed, I told her. I've got water rights on file with the state going back to 1961. Whatever's happening with your sprinklers, it isn't coming from my irrigation. She didn't argue with me that day. She just nodded, thanked me for my time, and drove back up the hill toward Fairview Meadows in her clean white SUV. I figured that would be the end of it. It wasn't. 3 weeks later, the first letter arrived. It came on HOA letterhead, informing me that the board had, quote, formally requested a hydrological study of the shared basin aquifer, and that pending the results, all agricultural well owners in the vicinity were asked to voluntarily reduce extraction by 30% as a precautionary community measure. I want to point out something important here. I wasn't a member of that HOA. I never had been. My land sat entirely outside the subdivision boundary, same as it always had. But the letter was addressed to me directly, like I was somehow obligated to follow rules for a community I'd never joined and never agreed to be part of. I called my neighbor, Roy Kessler, who's run cattle on the section next to mine for almost as long as I've been farming. Roy's the kind of man who reads state water board bulletins for fun, which sounds strange until you understand how much water matters out here. You get one of these letters too? I asked him. Nope, Roy said, because my water rights are filed under a family trust from the 50s, same as yours, and neither one of us signed up for anything those HOA folks are trying to regulate. You didn't respond to that letter, did you? Not yet. Don't, he said. Not until you talk to somebody who actually knows water law, because there's something about this that smells wrong to me. Roy had good instincts. I should have listened to him sooner than I did. The letters kept coming after that, each one a little more insistent than the last. The second one suggested that continued extraction at current levels could result in the HOA pursuing what they called, and I remember this phrase exactly, protective legal remedies on behalf of affected residents. The third one arrived with a copy of an engineering report attached. 12 pages of technical language claiming that the aquifer beneath our basin was showing signs of significant depletion, and that agricultural wells in the immediate area, meaning mine and Roy's, were the most likely cause. I'll admit that third letter rattled me a little because it had charts in it, actual data, water table measurements over an 18-month period showing a steady decline. It looked official. It looked like something I should be worried about. So I did what I probably should have done from the very beginning. I drove into town and paid a visit to the County Water Resources office. A woman named Carol Estrada pulled my file for me, along with the historical water table records for the entire basin going back nearly 40 years. She spread everything out across a big table in the records room and let me look through it myself. Your well's been drawing pretty consistently for decades, she said. Same average output, same seasonal patterns every year. If anything's stressing this aquifer, it isn't coming from your operation. Then what is? She pulled up a different set of records, newer ones, dated from right around the time Fairview Meadows broke ground. 400 homes, she said. Every one of them with an irrigated lawn, most of them with a pool, and all of it pulling from private wells the developer drilled instead of connecting to the municipal water line, because connecting would have cost them permits and fees they didn't want to pay. I sat with that for a minute. So their subdivision is what's actually pulling the water table down. That would be my professional guess, Carol said, but I'd want an independent hydrologist to confirm it before you say that anywhere official. That was the first real crack in the story Priscilla Vance had been telling everyone, but it wasn't the last thing I found in that records room. Not by a long shot. While I was there, Carol mentioned something almost in passing that ended up mattering more than either of us realized at the time. You know your family's water right isn't just a regular agricultural permit, right? She asked. I told her I knew we'd had rights on file since 1961, same as most of the ranchers out here. It's a little more than that, she said, and pulled a different, older file, one with a faded cover and handwriting instead of typeset print. Your grandfather filed what's called a senior appropriative right, tied to a natural spring source that feeds directly into this basin. It predates almost every other water right in the area, including, as far as I can tell, whatever arrangement the Fairview Meadows developer worked out for the subdivision's water system. I didn't fully understand what that meant yet, not the legal weight of it, but Carol could see the confusion on my face, so she explained it plain and simple. Out here, water law runs on a first-in-time, first-in-right system, she said. Whoever filed their claim first gets priority when water gets scarce. Your grandfather's claim goes back to 1961. Whatever water right Fairview Meadows is operating under, if they even have one properly filed, it's going to be junior to yours by decades. I asked her what that would actually mean in practice. It could mean, she said carefully, that if this basin really is under stress and water does become scarce enough to matter, your family's right to draw from it comes before theirs, not the other way around. I left that records office with a folder full of copies and a feeling in my chest I hadn't had in months, something between disbelief and the beginning of a plan. I called an attorney the same week, a sharp woman named Denise Aquifer who specialized in water law, which is a surprisingly specific and surprisingly busy specialty out in this part of the country. She spent almost 2 hours going through everything Carol had given me, along with the letters from the HOA and their engineering report. This report they sent you, she said, tapping the pages. It doesn't actually name a licensed hydrologist anywhere. No signature, no state registration number, nothing you'd expect from a legitimate engineering study. So it's fake? I wouldn't say fake exactly, I'd say it's dressed up to look more official than it actually is. It reads like something written by someone trying to build a case rather than someone trying to find the truth. She asked me not to respond to any more letters directly, and instead let her office handle all future correspondence with the HOA. For a while, that seemed to work. The letters slowed down. I actually started to think the whole thing might quietly fade away, the way most overreaching HOA nonsense eventually does once somebody with legal standing pushes back. Then the lawsuit arrived. The complaint named me directly, along with Roy Kessler and 2 other agricultural landowners in the basin. It claimed that our combined extraction was, quote, materially and unreasonably depleting a shared community water resource, and it asked the court for an emergency injunction limiting our well usage while the case proceeded, along with that $240,000 damages figure, meant to cover what the HOA claimed were declining property values tied to unreliable water pressure. Denise wasn't worried, not the way I was. If anything, she looked almost pleased when she finished reading it. "They just made a mistake," she told me over the phone. "Feels like a pretty big mistake to be on the receiving end of," I said. "No, I mean a legal mistake. Filing a lawsuit means discovery. Discovery means we get to see exactly what water rights, if any, Fairview Meadows Estates is actually operating under. Up until now, that's all been buried in permit applications we didn't have standing to request. Now we do." It took about 6 weeks for the discovery documents to come through, and when they did, Denise called me into her office on a Tuesday morning with a look on her face that told me something significant had turned up. She spread 3 documents across her desk. The first was the original well permit for the Fairview Meadows development, filed by the developer 8 years earlier. The second was a temporary water allocation agreement between that same developer and the county, dated the same year construction began. The third was an expiration notice, issued 4 years ago, informing the developer that their temporary allocation had lapsed and needed to be converted to a permanent appropriative right through a formal filing process. "They never filed the conversion," Denise said. "Their temporary allocation expired 4 years ago, and as far as county records show, nobody at Fairview Meadows Estates, not the original developer, not the HOA that took over water system management after the development sold out, ever completed the paperwork to make it permanent." I stared at the papers for a long moment. "So what does that mean for their 400 wells?" "It means," Denise said, "that legally speaking, Fairview Meadows Estates has been operating without a properly secured water right for the last 4 years. Meanwhile, your grandfather's senior appropriative right from 1961 has been valid, unbroken, and properly filed this entire time." I sat back in my chair and let that settle in. The lawsuit that Priscilla Vance had filed against me for allegedly stealing water from her community had just handed my attorney the exact documentation needed to prove that the community itself had no properly secured legal claim to that water at all. Denise filed our response within the month, and it wasn't a simple denial of the HOA's claims. It was a formal counter-petition, asking the court to recognize my family's senior water right, and more importantly, asking the county water board to review whether Fairview Meadows Estates was drawing water it had no current legal right to draw at all. Word travels fast in communities built around shared resources, and it wasn't long before residents inside Fairview Meadows started hearing rumors that something was seriously wrong with the neighborhood's water situation. A woman named Louise Ferrante, who lived on the eastern edge of the subdivision and had served 2 terms on the HOA Finance Committee before resigning in frustration the year before, reached out to me directly after hearing about the lawsuit through a mutual acquaintance. I tried to raise questions about the water system budget for over a year, she told me when we met at a diner in town. Every time I asked how the annual water assessment fees were being spent, I got told it was covered under infrastructure maintenance, and the board would move on to the next agenda item before I could ask a follow-up question. She brought a folder of her own meeting notes and copies of financial disclosures, showing that Fairview Meadows had been collecting a substantial water infrastructure fee from every homeowner for years, money that, according to her records, had never actually gone toward securing the permanent water right the development desperately needed. "Where did the money go?" I asked her. Louise just shook her head. "I asked that question for 2 years, Mr. Cross. I never got a straight answer, not once." The county scheduled a public hearing on the water allocation issue about 10 weeks after the lawsuit was filed, and by then enough residents inside Fairview Meadows had started asking their own questions that the meeting hall was standing room only. Priscilla Vance sat at the front table with the HOA's attorney, looking considerably less composed than she had the day she'd stood at my front gate with that bottle of sparkling water. The county's water resources director opened the meeting by laying out the basic facts, plainly and without drama, the same way Carol Estrada had laid them out for me months earlier. The temporary allocation, the expiration, the missing conversion filing, the senior appropriative right on file under my family's name since 1961. Priscilla tried to frame it as a bureaucratic oversight, something the HOA's water management contractor should have handled and simply failed to follow through on properly. But Louise Ferrante stood up from the crowd before the director had even finished responding, holding her folder of old meeting notes. "I asked about this exact filing at 3 separate board meetings," Louise said, her voice carrying clearly across the packed room. "I was told each time that it had already been handled. Can someone explain why it wasn't?" Priscilla didn't have a good answer because there wasn't one. The silence that followed said more than any explanation could have. Another resident stood up after that, then another, each one adding a piece to a picture that was becoming impossible to ignore. Homeowners who'd paid water infrastructure fees for years without ever seeing an itemized breakdown of where that money actually went. A board that had spent months pursuing a lawsuit against outside ranchers instead of addressing its own expired water permit. And at the center of it, a woman who had built her entire authority on being the person who handled things, now standing in front of a room full of people realizing she hadn't handled anything at all. The county water board didn't rule that night. These things rarely resolve in a single dramatic moment the way people sometimes wish they would, but the direction was clear enough. Fairview Meadows Estates was ordered to immediately cease new well permitting until a proper permanent allocation could be filed and reviewed, and the HOA's lawsuit against me, Roy, and the other 2 landowners was formally dismissed within the month, along with a fairly pointed note from the judge suggesting that any future claims regarding shared water resources should be brought with, quote, considerably more diligence regarding the claimant's own legal standing. Priscilla Vance resigned from the HOA board about 6 weeks after that hearing. I heard through Louise that she and her husband ended up selling their house and moving out of the subdivision entirely within the year, though I couldn't tell you if that part is true or just the kind of story that grows a little in the retelling once it starts getting passed around a small community. Fairview Meadows eventually filed the proper permanent water allocation, working cooperatively with the county this time, instead of trying to solve their problem by pointing fingers at the ranchers who'd been there decades before their first house was ever framed up. Denise told me later that as part of the settlement discussions, the new HOA board formally acknowledged my family's senior water right in writing, which wasn't strictly necessary given that the state records already made it clear. But it felt like the right kind of closure all the same. I never went looking for a fight with anybody. I just wanted to keep running my alfalfa and my cattle the same way my grandfather did, and his father's well before that. But I've learned something out here over the years that I think applies well beyond water rights and property lines. People who build something on borrowed ground, whether it's borrowed water, borrowed authority, or just borrowed confidence, tend to get loud right before that ground gives out from under them. My well is still running today, same steady output it's had for over 60 years now. Roy still teases me about the whole thing whenever he sees me at the feed store, tells me I should frame that original lawsuit and hang it in my barn as a reminder of the day a homeowners association found out exactly whose water they'd been standing on top of the whole time. I probably will one of these days, right next to my grandfather's old drilling permit in the same frame if I can find one big enough. Because in the end, that's really what this whole thing was about. Not spite, not revenge, Just the plain fact that some things get decided the moment you write your name down first, and no amount of paperwork drawn up decades later ever changes whose name came first on that page.